Okay, we are continuing with the types of contract. The last one we talked about was quasi contract, where we learned that at times there may not be contract between the parties, but one person might have been unjustly enraged. The court will ask the other party who is not ready to make restitution, the court will create that quasi contract for you to make a restitution, to pay a reasonable price for what you have unjustly enriched yourself with. And I gave you example to that effect. So that is the quasi contract. Now let's move to the next type, valid contract. When you say something is valid, what does that mean? Valid. Now when you say a contract is valid, you know, for example, we learned that a contract is any agreement between two or more parties which is enforceable by law. We have learned that one. So what makes a contract enforceable by law? That means that for a contract to be enforceable by law, it must fulfill certain elements. Certain elements must be present. It must satisfy all the conditions that have been laid down by law. If the law says for a contract to be valid, A, B, C, D should be done. That means A, B, C, D have been done. Then it means the contract is valid. And once a contract is valid, then it means it can be enforced. So that is what is meant by a valid contract. A valid contract is the one that satisfies all the conditions that have been laid down by court, and that it can be enforced. Very soon we shall learn about all the essential elements that make a contract valid. So when you say a contract is valid, what are the conditions that have been laid down by law to make it valid? Very soon we shall learn about that. But remember that a contract's validity can be affected by certain things. A contract's validity can be affected by certain. In other words, there are certain things when they are present, they will make a contract invalid. And so it means that those things have affected the validity of the contract. And what are those things? Number one, mistake. When there is an error, when there is a fundamental error. If you are entering into a contract and you made a mistake, we shall learn about what mistake is in full. But at least when you say you have made a mistake, in even ordinary English, you understand when there is an error. For example, you ask somebody to supply you with, let's say, football, and the person thought you were talking about football boot, and the person brought football boot. It means there's a mistake, there's a fundamental error. And that one, it means there is no contract. So when there's a mistake, it will make the contract void. So mistake, when there is a mistake will make a contract void. When there is a mistake, it will make a contract void. So we shall learn about what is a void contract. Number two, misrepresentation. What is misrepresentation? In law, representation are the statements that you make when you are entering into contract. You remember I read a certain document to you. The statements that you make. For example, some of you have even rented apartments, private hostel, where you live and then come to school. Is that not it? You entered into a contract with the landlord or the landlady. And there are certain obligations you are supposed to fulfill. For example, the person will tell you, you have to pay 500 Ghana cedis. All minor repairs you make, you will not pay electricity bill, you prepare your own food. These are the statements that you have made. The person will have to fulfill certain obligations. You also have to perform certain obligations. You have certain rights. The person also has certain rights. These statements that you make when you are entering into contract, they are called representations. Representation. When you make a false statement, then it becomes misrepresentation. So when there is a misrepresentation, it will affect the validity of the contract, and it will make the contract voidable. So we shall learn about what is voidable contract. Another thing is duress. Duress. When somebody forces you, when somebody threatens you to enter into a contract. For example, somebody made a threat that if you don't sell your house to me, I'll kill you. That's a threat. Can the person carry out does the person have what it takes to carry out that threat? If the person has what it takes to carry out that threat, the person is capable of carrying that threat, then in law it is called duress. The threat is called duress. The person forced you to do what you didn't want to do or you shouldn't have done. But if it had not been the threat, you wouldn't have done that. In law they say duress. So when you enter into a contract under duress, it will affect the contract validity, and it will also make the contract voidable. I will explain to you what is meant by voidable. Another thing is undue influence. When somebody uses his position of trust to force you to enter into a contract with you. You know, I'm a teacher. Assume you have a very nice phone, and I didn't threaten you that if you don't give me the phone, I'll do this to you. But I just asked, will you sell your phone to me? You see, I'm a teacher and you are a student. And because we don't have equal bargaining strength, maybe you see, you might have sold the phone because I'm your teacher. Yes. In law, they say there is an undue influence. Undue influence. Undue influence. If I take advantage of my position, if I take advantage of some of the fact that somebody was in the stress situation to enter into a contract with the person, somebody whose state of mind was not right at a certain point in time, the person was drunk, you take advantage of that for the person to enter into a contract with you. All these will be under undue influence, and it will affect the validity of the contract, and it will make the contract voidable. I will explain to you what is meant by voidable. So, mistake, duress, undue influence, and misrepresentation will affect the validity of the contract. And they will either make the contract void or voidable. And note, I said mistake will make it void. In general, mistakes will make a contract void. But it's not all mistakes that make a contract void. But in general, mistakes will make a contract void. And what is a void contract? We know it very soon. Then, duress, undue influence, and misrepresentation will make a contract voidable. This is something you must note. And note the effect of mistake on a contract, and the effect on duress, undue influence, misrepresentation on the contract. So what is a void contract? When you say a contract is void, what does that mean? It's the opposite of this. It means it is invalid. So another term for void is invalid contract. That means it is as if there is no contract between the two of you. So void contract means there was no contract between the two of you. What does that mean? Understand it this way. It is not as if you did not meet somebody to make some negotiations. You might have met, and you might have thought, you might have entered into an agreement. But because of one reason or another, it is as if, even though you have entered into a contract, you thought you had entered into a contract, because of that, because that element has come in, it is as if you have not entered into a contract. For example, you entered into a contract with somebody and you ask the person to supply you laptop. Now, the person thought you needed desktop computer. So the person brought desktop computer instead of laptop. In law, they say there was no agreement. There was no, your minds did not meet. The two of you did not have the same understanding. In that case, there is a mistake. There is a fundamental error. And because there is that mistake, it has made the contract void. What it means that it is like you people have not entered into a contract. That is what is meant by void contract. And mistake will make a contract void. What is voidable? Voidable contracts are valid contracts. They are valid, except that one of the parties, the injured party. In law, when you say injured party, who is the person? Okay, you ask somebody to supply you raw materials. Is that not it? Okay, you pay 30,000 Ghana cedis. Very good. The person has applied. Is that not it? And you have not paid. It means the person who has paid is an injured party. And the injured party can take you to court for redress, for the court to enforce the agreement for you to do what you are supposed to do. So that is who the injured party, the innocent party. The innocent party. So in a voidable contract, the innocent party has at his option. So it is optional. The person can decide to do it or not to do it. To rescind. To rescind. R-E-S-C-I-N-D. To rescind. Or to repudiate. To repudiate. To repudiate. Or to withdraw. The three words mean the same. So when there is a contract and the law allows the injured party, now you know who an injured party is, to rescind or repudiate. These are law terms. Rescind, repudiate, and the simple one you may understand is withdraw. So now you understand what is meant by to repudiate. To withdraw from the contract. Okay, you have entered into a contract with somebody. You realize that the person made a false statement. So there is misrepresentation. The person told you the phone he was selling to you was brand new. That is why you bought it. Later you found out that it was not brand new. The person lied to you. The person made a false statement. So it is called misrepresentation. When there is misrepresentation, you have the right to withdraw from the contract. What does that mean? You return the phone to the person at your wish if you want to, and then you take your money. The person cannot say he will not give your money to you. Why? Because the person made a false statement. And the law says that once the person has made that false statement, you, the injured party, you have the right to rescind. So you say you are rescinding, you are withdrawing, you are repudiating. So the person doesn't have that option. That's why we said that a voidable contract is the one that one party has the option to rescind or repudiate from the contract. Now, when there is misrepresentation, you can do that. When there is duress, you can do that. When there is undue influence, you can do that. But so long as you have not rescinded, the contract is still valid. That is what you must know. So the contract, you can decide, okay, you have made a false statement, but I will still continue the contract. I still like the phone, I'm taking it. The person cannot come to you and say that I have made a false statement, so take your money and give my food. The option is not at the person's end. You have the option to rescind. So it is optional. It is optional. So that is what voidable contract is. That's how we can distinguish between voidable contract and the void contract. For the void, there is no contract. So it doesn't have any effect. So if, for example, the computer, you decide not to, you will not pay, the person cannot take any legal action against you. But for the voidable contract, if you want to rescind, you can rescind. But so long as you have not rescinded, the contract is still valid. But be very careful. If the contract is voidable and you want to rescind, do it within a reasonable time. Because if you don't do that and the party passes the property to another party, you cannot rescind. You cannot avoid it. Why? Because at the time the person was passing the property, there was a valid contract. I'm going to repeat it. What I'm saying is that if a contract is voidable and you want to rescind, then do that within a reasonable time before the party passes right to another person. Avoid it at the right time because it is a valid contract. So if you allow the person to pass it to another person, you cannot get it, you cannot withdraw. So take note of that. So that is the voidable contract. The last one for today is unenforceable contract. Unenforceable contract. Take note of that. Listen to the explanation very well and try to distinguish it from void contract. Some people don't know the difference between void contract and unenforceable contract. Take note of that. So I'm going to take my time to explain what is unenforceable contract. Number one, when you say a contract is unenforceable, unlike a void contract, that means there is no contract. Here, the contract is valid. That is the first thing you have to know about unenforceable contract. They are valid contract, except that they cannot be enforced in court. And I have already explained to you what is meant by enforcing contract. And we learned that the courts exist to enforce agreement made by the parties. The parties themselves will enter into agreement, but the court will see to that if one of the parties fails to perform their obligation under the contract. In other words, if one of the parties fails to perform his or her obligation under the contract, then the court will try to compel, the court will force you, the court will ask you to do what you should have done. So the court is enforcing it. But when we say a contract is and you know this when prefix and, it means not. So unenforceable is not enforceable. Not enforceable doesn't mean it is not valid. But it cannot be enforced. Why can't it be enforced? You see, you have gone to court and the court said, no, as for this matter, this case, you can't bring it to court. That is what is meant by it is not enforced. How? Let's move to this place. You know, we learned about specialty contracts. And we said those contracts are made by deed. It must be signed, and I showed you a document that had been written, signed by both parties, and it was witnessed, and it was being done in court, and there is a seal. Now, and what was it? When you are purchasing a piece of land, that is what should be done. But you were purchasing a piece of land, and you did not do that. You only made it oral. That means it is not enforceable. Number two, there is a contract. The court says this contract must be written. You cannot enter into this contract if by oral means. By oral means. let's move to this place again. When we are talking about simple contract, you see, there are several forms you can enter into simple contract. So, forms that a simple contract can be entered into. Number one, now remember, we are looking at types of contract. It is not the same as form that a contract will be entered into. The form is that it can be written. That's one of the forms. Another form is that the contract can be oral. Another form is that it can be implied. And the written and then the oral, the two together are called express. So a contract can, one of the form can be express, which is written or oral. You go to market, somebody is selling tomatoes. You go and say, please, I'm buying tomatoes. How much is it? It's oral. You don't write it. Some contracts too, you write it, and the offer will be written, and then it is sent to the person. The person may also have to accept it by giving you letter. Now, okay, let me ask you this question. If you apply for employment at a workplace, when do you get the employment? They have advertised. Then you make an offer. You apply to be employed. When are they going to accept it? When will acceptance take place? That is the time they will give appointment letter. An appointment letter is written. So you cannot use your mouth to say you have appointed someone. It must be written. It is written. Appointment letter, it is written. So if you don't write it, it did not take that form. There's no evidence to the effect that you have been employed. A contract that is supposed to be written, if you make it oral, it cannot be enforced. And in law, they say that that contract has technical defect. Get closer to it and let's see. Technical defect. What is the technical defect? You were supposed to have written it, but you made it oral. It was supposed to have been made by deed or under seal. That is specialty contract, but it was just written. It was not written by a third party. Such contracts are said to have technical defect and they cannot be enforced in court. Even if there had been exchange of promises, if you have paid for something, it is still valid, but the court, they will not go through the judicial process. They will not call the case, your case will not be accepted in court. So you have to go home and do your own settlement. It is not invalid. It is not invalid. It is not invalid. It is not like the void contract. But they are contracts that the parties have entered into, which are valid but cannot be enforced because there is technical defect. And I've explained to you what is meant by technical defect. In other words, a contract is supposed to have been written, you made it oral. Ladies and gentlemen, that brings us to the end of today's lesson. Remember, you have 3 short videos because of a technical problem. We talk about the meaning of contract. Then we also talk about types of contract. We have talked about 11 of them. So now, if you are asked what is a contract, you should be able to tell me what a contract is. If you are to distinguish between domestic agreement and then social agreement, you should be able to distinguish between domestic agreement and social agreement. And you should be able to explain why domestic agreements are not enforceable. Then you should be able to mention, we have talked about 11 types of contract. You should be able to at least mention 5 of them. And you should be able to explain vividly what they are. We shall meet another time and continue. Please, I will be putting this particular case. You can go to YouTube All the cases have been dramatized, so you can see drama of the cases. I'll put them on your YouTube, no, the WhatsApp platform, so that you can follow the link and then watch the cases. Today we did one case, Carlyle versus the Carbolic Smoke Ball Company Limited, and we talked about what the case was and then how it was held. To meet again another time and talk about the essential elements of a valid contract. It's bye-bye.